Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. Anne and I have returned. Anne, of course, is Anne Lipton. She's a law professor at the University of Colorado who teaches and researches securities and business law. She looks after the legal part of our little podcast enterprise here.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
I try to. Anyway, go ahead. You have something you want to tell us about?
Yeah, just a reminder, if you want to get in touch with us for any reason, you can email us at shareholderprimacy@prefloat.llc.
Yes, please send emails. We could use a few. We're not running out of ideas, but we like to hear from everybody about what they want us to talk about. Anyway, Anne, this past week, there was a brief, intense, and interesting news event, interesting and potentially important in a deal. And that's the one among and between Pfizer, Novo Nordisk, and Metsera. And Pfizer and Novo were competing to acquire this drug company, Metsera. We did hear, after you and I sketched all this out, what we wanted to talk about, that Pfizer, in fact, prevailed. Pfizer won this kind of quasi-pseudo auction. It wasn't even that.
It was an auction.
It was an auction? Okay.
It
wasn't an auctioneer, but they were going back and forth.
Yeah.
And the deal is back on. So Pfizer is now on the hook to acquire Metsera with some really interesting twists and turns and some terms. And Pfizer is paying something like a quarter or a third more than it originally proposed, $2.7 billion more than its first bid. So on top of its original bid of $7.3 billion, that's a lot of money.
Yeah, on top of the bid that it thought it had an agreement.
Yes, exactly. They thought this was a slam dunk. So even though as of a few days ago, it's presumably over, or at least the competing part, we thought we could outline some of the basic details, and then also talk over some really, delicious legal issues.
Yeah, there were some really interesting legal skirmishing that happened in the course of all this.
Right. So, but the timing was a little weird for us, wasn't it? I think.
Yeah. The whole thing resolved in a couple of days. So it's only been going on for like less than a week. But I'll just say at the outset that we are recording this on the morning of November 10th, and we're going to make this podcast public on the morning of November 12th. So if anything dramatic happens between those two times, we're going to be a little out of date. But as of the morning of November 10th, here's where we are.
So followers, forgive us if something crashes and burns in this deal in the next 48 hours or even after. But we hope to guide everybody through at least what we thought was kind of interesting. Let's look at some of the issues. The players, of course, I'll talk about that for a sec. The players are Pfizer, who everybody got to know by now. Of course, developed, some of the original COVID vaccines, long time, centuries old U.S. pharma company, remained actually kind of independent up till now. But importantly, their problem is they do not have a horse in the weight loss race. They do not have a GLP-1 drug. They had one that went somewhat far into some trials and then just failed. The other bidder here is Novo Nordisk, which everybody kind of knows sort of who they are. They're more of a one-trick pony. They have other drugs, but they're the Ozempic and Wegovy people, and have made just boatloads of money.
Yeah, but they've been stumbling for whatever reason recently.
The most recent years' share price performance has been not great.
But they do have these two blockbuster weight loss drugs.
Right. Novo, I don't know if you knew this, they are by far the biggest company in Denmark, where they're domiciled. Their market cap, and again, I always hesitate a little bit to mix stock numbers like market cap with flow numbers like GDP, but their market cap of $700 billion is larger than the Denmark economy.
Yeah,
they're dominant. And then there's Metsera. Who is now? You looked at Metsera.
Yeah. So Metsera, they only just went public this January, and apparently they were negotiating a merger even then. But they only just went public this January, and they have these new weight loss drugs of the same class in development that are apparently very promising, but they are not yet there. They're not yet on the market. Right. And it's a venture capital backed company. It's got two big funds that are backing it. And those funds and their affiliates have a majority of the voting power, and the company founders have the voting power. So it's publicly traded, but a lot of the voting power is.
It's all really concentrated.
And it was the VC backers and the founders.
And it was an IPO within the past 12 months, which itself is a little notable.
It's not even a seasoned issuer under securities regulation.
And they have like zero revenues. Yeah, all they've done is pile up just like lots of losses. Yeah. So they're basically a drug development company with a promising drug, though it's not assured. They don't have any kind of FDA approval yet to sell it, or it's just this kind of flyer. And then Pfizer, because they don't have one of these. Go ahead.
Yeah, so like a bunch of companies were looking to acquire them. And as I said, even before, apparently these talks were beginning, even before they had the IPO. I mean, that's an interesting decision that they had the IPO while having discussions, but whatever. So they had actually a whole bunch of different acquirers that were interested in them, but essentially two were the most promising. Pfizer, because that would give Pfizer the foothold in this weight loss market that it doesn't currently have. Yes. And Novo, which obviously is well established in this market because Novo wanted to preserve its position as the dominant player and also shore up, its stock price after the problems they've been having. So after several rounds of bidding and a lot of negotiations, both of them had the same basic proposal financially. So both of them proposed to merge with Metsera and buy out the stockholders for cash plus a contingent value right. And the contingent value right, a CVR, it wouldn't trade, but basically it's essentially the equivalent of what you do as an earnout in a public company.
Yes,
it would pay out additional cash if Metsera's drugs in development met certain milestones, for effectiveness and FDA approval and so forth. So, and this is very common in drug companies, and also the litigation that follows is very common in drug companies where there are drugs in development. They could either be worth everything or they could be worth nothing. So when you buy out the stockholders, you pay a contingent value right that will give them additional cash if the drug turns out to be successful.
If it succeeds.
Right, exactly. So by the time the dust settled, with multiple rounds of bidding. So both of them were proposing cash for the stock plus a CVR. And by the time all of this bidding happened, Novo's bid was absolutely higher by any measure. It was offering,
like in terms of like a total valuation.
In every measure. It was offering $50 in cash plus a CVR that would pay out a maximum of $37 per share. And Pfizer was only offering $47.50 per share in cash. Plus a $22.50 CVR. So on every possible measure, Pfizer's bid was lower.
It was inferior.
But there was a big stumbling block to Novo's bid, and that's antitrust. Because Novo, with two weight loss drugs in its portfolio, presented a lot more antitrust risk than Pfizer, which had no weight loss drugs in its portfolio.
Right.
And the big
so
issue,
when we talk about antitrust, I'm going to interrupt you. When we talk about antitrust risk, we mean whether I'm guessing the FTC, not the FDA, whether the FTC would allow this merger to go forward.
And it's more than that. Not just that. There's a particular statute called Hart-Scott-Rodino, HSR.
Yes, right.
So basically the backstory here is that what companies would used to do is if they knew that if they presented antitrust risk, they would rush to merge really quickly before the government could stop them, figuring that even if the government sued after the fact, it's really hard to unscramble the egg.
Unwind it. Yeah, right. Yeah.
Exactly. So Hart-Scott-Rodino is this pre-clearance system where if your merger is of a certain size that involves either buying up assets or taking voting control, you have to pre-clear it with the government. And if the government doesn't think there's a problem, it's just a waiting period and you sit around and you then merge. But if the government does think it's a problem, it can ask for discovery and you can get into a really prolonged discovery process that ends, if worst case scenario, with the government going to court to block you. So the big issue here was that Novo had such high antitrust risk. There was this whole discovery period before they could actually do the merger threatened to be very prolonged and very uncertain. So Novo came up with this novel workaround. And
that's what I'm kind of curious about.
Yeah,
Go ahead.
So the idea would be to have two different pieces to the merger. First, as soon as Metsera signed the merger agreement, Novo would pay the cash portion, the $50 per share in cash, straight to Metsera, just at signing, before there's even a shareholder vote. At signing, they would pay this cash to Metsera, and Metsera would pay that cash out as a dividend to its own shareholders. And in exchange, Metsera would give Novo about half the company, the economic value of the company, but in non-voting stock. And Hart-Scott-Rodino only applies if you're selling assets or voting control. Non-voting stock does not require pre-clearance. So the theory was that this first half of the transaction could just happen right away without going to the FTC. Novo would get half the company, but only in non-voting stock. It would be financially half, though. It would be entitled to dividends and all of that. But It would be non-voting stock worth half the company, and they would pay all the cash up front, and Metsera would have that.
So the entire part of the cash structure was going to be paid out now.
Immediately. And so all that would be left would be the contingent value right, which was much less. So I haven't done the math. Let's say 2/3 would be paid out right away.
Yes.
And then the company would sort of fight it out with regulators, hopefully. And then if the regulators ultimately approved, then they would have the merger and the shareholders would get the back end consideration, which would be the contingent value right. And if the shareholders, and if the, but if the merger wasn't approved by regulators, then Novo would just continue on owning half the company, non-voting stock, but with economic value. The shareholders of Metsera would still have their cash. It would be the equivalent of a massive break fee. And, they'd still have half their own company. Now, the problem,
that's an interesting way to think about it.
Yeah.
That it was just the break fee being paid up front before Metsera did a damn thing.
Exactly. And now what it would mean is they'd still have financially half their company. If their drug turned out to be incredibly valuable, they'd still have half of that. But it also means that there would be a huge stumbling block if anyone else wanted to take over the company, because they'd have to buy out Novo.
Right. They have to pay out. They'd have to.
It had a liquidation preference. It basically got back what it paid in. So any future acquirer would have to buy essentially half of Metsera from the public stockholders and then buy out Novo. So in many ways, this is a really advantageous structure, because the absolute worst case scenario is that they sell half their company for what, is actually financially probably a lot more than half their company.
Right. Yeah.
But Metsera decided this was too risky. Partly because this waiting period, while they waited to see if the merger got approved by the FTC, would just introduce so much uncertainty for the company that it would just really weigh on the business.
Yes.
But the other reason, and this is in Metsera's proxy statement, I'm quoting it now. With Novo's bid, there was, and this is the quote, the risk that the payment of the initial cash consideration and the subsequent payment of the dividend in respect of shares of Metsera common stock may not occur. That was the concern, that upfront cash payment wouldn't ever happen. So the question is why? Well, they didn't say why, but what I gather why is because the Hart-Scott-Rodino Act would view this as an evasion. Like, it actually says you can't restructure a merger transaction to try
with the non-voting shares.
Exactly. And this has actually happened before. The DOJ has fined companies for this, for doing exactly this, essentially. So Metsera,
the lawyers here didn't invent this.
Did not invent this. So Metsera was apparently concerned. I mean, this is what I'm reading between the lines here. Not only that this structure would still violate Hart-Scott-Rodino, but they were apparently concerned that the government would be annoyed enough that before they could even get that initial cash, they would actually go to court to try to get an injunction to stop it.
Got it. Oh, interesting.
So that's what I take from this. So given all of these risks, it went with the lower bid of Pfizer. And this was all agreed to on September 22nd. It wasn't very long ago. But apparently, shortly after signing with Pfizer, Novo and Metsera start talking again. Except now, Metsera has a merger agreement with Pfizer. And the agreement restricts Metsera's ability to accept any topping bid. It can't just say, well, Novo's higher now. So under the agreement, Metsera is only allowed to accept a topping bid if that bid counts as a superior proposal. And a superior proposal has a very specific definition in the merger agreement. It's not just more money. To be a superior proposal, the board has to conclude in good faith that it's financially superior taking into account all of the regulatory risks. And it has to be about as likely to be completed according to its terms as the Pfizer deal is. So it has to be financially superior and about equivalent to Pfizer in terms of likelihood of completion.
Or no less is likely as than Pfizer.
Given all the regulatory risks.
Pfizer, I know they were highly confident that there was no antitrust risk with Pfizer.
Not only that, they got their waiting period for Hart-Scott-Rodino was early. They got early termination. It was so obvious. That the FTC basically said we don't even have to worry about this. So plus, and it's more than that. Plus, the board has to not only conclude that it's financially superior and that given the risks, it's still likely to be completed and so forth. The board has to conclude in good faith that the new proposal is so much better than Pfizer's deal, that the regulatory risks are so minimal that it would actually be a breach of fiduciary duty not to take it.
That's a very high bar.
That is an extremely high bar.
Is Metsera Delaware?
Yes,
Delaware,
they're all Delaware.
Okay, so they're all Delaware corporations.
Well, not Novo.
Right, okay.
That's right. But it's a pretty high bar, but it's not unusual if the company already has gone through a lot of bidding. Like locking it up that tightly would be bad if you just like went with the first bidder.
Right.
But it's not. But I've seen that. I've definitely seen things like that before when the company has already negotiated quite a bit, and Pfizer was obviously concerned because it knew that Novo was out there.
Yeah, Novo
as its main competitor.
You said they'd been doing this since the IPO. They'd been talking to
exactly.
everybody.
So they knew exactly what the risks were. But so they locked up this deal really tightly with it has to be financially superior given the regulatory risks, about as likely to be completed on its terms as Pfizer's is, and it would have to be a breach of fiduciary duty for Metsera not to take it. That is the standard for terminating in favor of the Novo deal. But what Novo comes back with to Metsera is exactly the same plan. Cash up front, CVR in the back, except now they've changed the dollar figures, so a lot more cash is being paid up front and the CVR is lower. It's actually less money total, but it's much more front-loaded. And then the bidding went on and Novo went even higher. But originally, Novo's new bid was exactly the same as the old bid in terms of structure, just with more cash up front. And this time, though, after apparently they brought this up with Pfizer that they were doing this, and Pfizer screamed bloody murder about liability. So Novo added an indemnification provision. The indemnification provision says that it would indemnify not only the company but also all of these. But not only the directors, but also the venture capital backer stockholders, the VC stockholders, from any damages in subsequent lawsuits. So Metsera goes and they tell Pfizer that Novo has a superior bid, which means that Pfizer has 4 days to counter. And Pfizer actually does counter, but it also sues.
That's what I was waiting
twice.
for.
Yeah, it sues twice. Two complaints were filed. One in the Delaware Court of Chancery and one in the Delaware Federal Court. The Chancery lawsuit is basically that Metsera is breaching the merger agreement and that this isn't a superior bid because the antitrust risk is still there. And Pfizer also sues Novo, claiming that Novo tortiously interfered with its Metsera contract.
Okay.
And then there's the federal court claim where this is an antitrust claim, claiming that Novo is essentially committing antitrust violations by trying to interfere with a competitor merger.
All right.
And then, but at the same time, Pfizer is continuing to up its bid for Metsera.
Right. All right. So it's the lawsuits that I think that really
the lawsuits that have my attention.
Some further debate and discussion. So why don't we cover those and talk about those and kind of where they went and what Delaware did and so forth after a quick break?
Yep. Okay.
All right, cool. We're going to take a quick break and we'll be back here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin, and we are continuing to look at the Metsera-Pfizer deal and the litigation that followed.
Metsera, Pfizer, Novo.
Novo deal, yeah.
Right, because that's how this kind of got started. All right, where we left this before the break was kind of setting the stage for all these competing bids and the antitrust risk. We didn't even really talk about regulatory risk in terms of drug approval.
Right.
But I
Well,
suppose
no,
that was
that's not
really
the issue. That's the same
equal
for
for both.
Yeah.
Both companies. I mean, that's a risk that I'd think about if I was a Pfizer shareholder, which I have been occasionally. I've never owned Novo shares, but I have been in Pfizer once in a while.
Well, that's why the CVR, and that's why. Well, I mean, it's not. I mean, that's partial. Well, I guess the regulatory risk if you pay out all this cash and they've got nothing, but that's the CVR,
right.
and they heavily negotiated what the actual milestones were.
Right. Okay. But anyway, but the main risk here was the antitrust.
Yeah.
And
exactly.
And Pfizer, I don't know if rightfully so, but Pfizer got very pissed off at what was happening.
Yeah, I got to tell you, my sympathies are at Pfizer on this,
right.
But yeah.
They marched right into two different courts, filed a bunch of different lawsuits, which we want to talk about for a little while. So what did, in order, should we start with Delaware Chancery? Or
well, that's really the main one. I mean, nothing. Okay. Yeah. So in Delaware, so the federal one is just simply that Novo is interfering with this transaction solely because if Novo figures if I can't have Metsera, it's better if Pfizer doesn't.
Right. That was in part. I was going to talk about this toward the end, but we'll return to it. That was part of what Novo was trying to do. They were not as much trying to get this drug because they already have good drugs. They're not doing great, but they were fine, and they have a whole. I think they were trying to keep this out of Pfizer's hands.
Yeah, that's exactly Pfizer's theory as well. So
and that'll probably come up here.
Was important.
Okay, go ahead.
Because in Delaware Court of Chancery, their fundamental argument is that this is a breach of contract. This is the breach of the merger agreement because Novo's bid is not superior under the merger agreement. And under the merger agreement, Metsera can't terminate unless it has a superior offer. And it comes down to the fact that to be superior, it has to be likely to be completed on its terms or at least as likely as the Pfizer bid. But nothing's changed from late September when Metsera concluded that the Novo bid was unacceptably high risk. Like there's no change. But Metsera claims actually in its papers, its argument is actually there was a change because after it signed with Pfizer, Metsera argues, Novo began talking to U.S. regulators. And now Metsera believes that Novo basically cleared a path with the U.S. regulators so that regulatory approval for antitrust is much clearer. It's much more likely. So coupled with the higher bid financially, then now Metsera is much more comfortable with the antitrust risk, and that's the reason this is a superior offer.
So just the act of Novo educating itself a little, but really jawboning the FTC seemed to persuade probably Novo and then by implication Metsera that FTC approval of this deal was somehow much more likely.
Yes, although that is their story. Whether it is truthful story is a whole separate question, which is why this is fun. Because, and I just got to say, in their papers, they make these fairly elaborate arguments about the complexity of the antitrust issues and how it might be very difficult for the government to demonstrate that Novo's bid was actually anti-competitive. But here's the thing, legally, that's not actually the question. Legally, the question is whether it's so obvious that the Novo bid, because now that they've got a merger agreement in place, the legal question is whether it's so obvious that the Novo bid would be completed that it would be a breach of fiduciary duty for Metsera not to take it. Oh. And that's a very different question from, well, actually, there are different antitrust arguments you can make. But anyway, if you read Pfizer's page, but nonetheless, Metsera's story is new information. We spoke to the regulators. We have a better sense now. And now we think that this deal
and now we're really confident, man. This is going to just fly through.
But if you read Pfizer's papers, there's a different argument that they kind of dance around. They don't say it, like they say it somewhat explicitly, but not that explicitly. But this is the implication. This is the story that Pfizer is telling.
Yes.
It's about the government shutdown.
Oh, interesting. Okay, go ahead.
Pfizer's argument is Novo has this bid structure of cash up front, and then if there's no merger approval, Metsera shareholders keep the cash. That's a really great deal for Metsera because it means, as we said before, worst case scenario, they get all the cash and they still have half their company. At the bidding numbers that we had now, Novo in effect pays shareholders $7.2 billion for half the company, which is a really good deal.
That's a great valuation, man.
But Metsera was concerned that the government would block that payment from being made, so no deal originally. But now with the government shutdown, Pfizer is suggesting, it looks like a better bet that the upfront payment will be made before FTC can act to stop it. And then once it's been paid out to shareholders as a dividend, there's no way for the government to get it back.
You can't put that toothpaste back in the tube.
And that's why Novo had to indemnify the VC backers, because if the government
because they're the ones who are going to get the
exactly, because if the government came after them belatedly, they can't go after all the public shareholders who got this special dividend, but they sure as hell can go after the VC backers.
And the VCs probably owned, significant blocks of these shares, and they know where to find them. They know where their banks are,
and they blame and also the founders who have significant things of stock. So that's why the indemnification was so necessary. So Metsera says that it only wanted this indemnity agreement because Pfizer threatened to sue. And maybe that's true, but I have to say this indemnity agreement doesn't just indemnify against litigation damages. It indemnifies against fines. Fines aren't what you pay to Pfizer. Fines are what you pay to the government.
Right, yeah.
So it sounds like this indemnity agreement was about government antitrust risk. So which puts a little damper on the story that, now we think that our antitrust risk
this is right. If they didn't think that was a remote threat, they wouldn't have.
Fines in the indemnity agreement.
These broad indemnity agreements in there, right?
But it gets better though. See, this is what I love. This is why I love this story. So as we've said, Novo would much rather wants to obtain Metsera and shore up its own position. But if it can't obtain Metsera, its best bet is nobody else does, because if Pfizer has it, it's going to be able to compete much better than Metsera can as a standalone. Right. So Novo's first choice is to get Metsera, and its second choice is just to keep Metsera as a standalone company.
They keep it on the sidelines for a couple years, right?
And that's why it's taking this. It's willing to take this huge risk on an upfront cash payment and nothing more. But that begs the question. Remember, the only reason there's antitrust risk here is because Novo is trying to take control of Metsera in the second half of the deal. What if Metsera and Novo just skip the second half? What if instead they just agreed Novo buys half of Metsera but non-voting stock only? That would be enough to keep Pfizer away, because it would be very expensive for Pfizer to buy out Novo. And if you didn't have that back half merger, you don't have HSR problem. Remember, buying the non-voting stock is fine. The only reason there's an HSR problem is because the non-voting stock is a prelude to taking over the company. So you might ask, well, if Novo's goal now is just to keep Pfizer away, why doesn't it just buy the non-voting stock outright for a big cash payment?
Right.
It keeps Pfizer away, and it's not an HSR. If there's no merger contemplated, it's not an HSR transaction. Okay. So the question is, why don't they just do that? There is an answer. The merger agreement. Metsera can only terminate for a superior deal, and a superior deal has a very specific definition. Someone acquiring 50% of the voting stock or 50% of the actual assets of the company. It doesn't include someone getting 50% non-voting interest. So I think Pfizer's theory, and they're sort of a little bit dancing around it, but their theory, I think, is that Novo's entire plan was just to make this upfront cash payment, essentially as a bribe, they call it a bribe, to Metsera to get it to terminate the Pfizer
in their
deal.
pleadings, in their complaint?
Yeah, I think it's in their briefing. They call it a bribe to Metsera to get it to terminate the Pfizer deal with no intention of consummating the back half. The back half is only part of the deal at all to bring this transaction within the definition of a superior offer so that Metsera can use it as an excuse to terminate.
Wow. Okay.
That's Pfizer's argument.
All right. So, and procedurally, this kind of got a couple of steps in front of Chancellor Zern, I think.
Yeah, it was before Vice Chancellor Zern, and they had two different hearings where Pfizer was asking for a TRO, a temporary restraining order, to get because Zern to halt the bidding and halt Metsera's threat to terminate. But she refused. Both times she refused to halt the bidding. She said partially, like, the last thing a Delaware court's going to do is interrupt an active bidding contest for the stock. But but what she said was, remember, Metsera can only terminate if it believes in good faith that this is a superior offer, it has to, et cetera, et cetera. And she said that Pfizer hadn't shown bad faith. So, and she also said, any problems, if Pfizer's right and there was a bad faith, and this wasn't good faith, and Metsera breached the merger agreement, then we can deal with that in the appropriate time. You don't need to interrupt the active bidding right now. So Pfizer was sort of forced into this bidding posture until it got up to Pfizer bidding $65.50 cash up front, $20.65 for the CVR. So just much more than the original.
So it was clearly a superior bid in every respect, including, but not only, the antitrust risk.
Right.
I mean, the economics were a lot better than what
the economics got a lot better for Metsera shareholders. And Novo sort of let it go there, but apparently that's not the reason it ended. What actually happened was that the FTC intervened during the shutdown. It intervened with a letter and then a phone call to Metsera, basically saying, no, seriously, this two-part structure with the cash up front and the back-end merger is really illegal.
We're gonna really look at this really carefully.
Exactly.
And the indemnification that you just provided everyone, you're going to have to pay a lot.
Or it might turn out to be illegal because it may not be possible to indemnify for illegal conduct. So FTC basically gives them a stern talking to, and Metsera says, all right, given that, we give up. Novo gives up, and they take this higher offer. But we have to suspect, there's been a lot of reporting that Pfizer's CEO has been seriously cultivating the Trump administration.
Yes.
And that may be why FTC intervened, not because they're wrong about whether it's illegal, but this is during a government shutdown. I mean, during the last government shutdown, like this, FTC wouldn't have given, say, early termination of the HSR waiting period, but it gave that to Pfizer anybody, during this. Anyway, so we don't know whether the reason FTC intervened was because of Pfizer's relationship with Trump or what, but this FTC letter puts things back to the start by saying, no, seriously, you can't structure the deal with Novo this way.
Right. This is going to be a problem. Yeah.
But I'm going it's not like I feel really bad for Pfizer, but I feel
Pfizer great for Metsera shareholders.
It's great for Metsera shareholders, mostly these VC backers. But Zurn, Vice Chancellor Zurn, she refused to halt the bidding, partially because she believed, well, I can always fix it later. We could deal with it later in terms of damages or whatever. But I think that kind of ignores the fact that when she refused to grant a temporary restraining order, Pfizer was kind of forced to counterbid. Like it didn't have a whole lot of choices to not counterbid. But the merger agreement was supposed to mean that it didn't have to counterbid. So it was kind of forced to counterbid, very possibly, even though it had contractual rights. So its contractual rights kind of fell by the wayside.
And as expressed in this original merger agreement that Pfizer thought was just signed, sealed, and delivered at that point. It was
completely locked up tight. So nonetheless, it was kind of forced to bid higher, even though, I think there's a good argument that Metsera really was breaching the agreement, and Pfizer should not have been forced to bid higher.
To raise its bid. So.
And so it's probably where things end. But there is this one little thing. Many years ago in the 80s, but there was a situation where Pennzoil was going to buy an oil company.
Oh my God, I remember that deal.
Texaco interfered with the bid, and Pennzoil sued Texaco for tortious interference and won like a $10 billion judgment.
Right. That was by far by magnitude the largest such judgment ever at that point.
Right. And it would never happen again. It was very Texas. It was a Texas jury. None of that's going on in Delaware. Nonetheless, Pfizer does have this outstanding claim for tortious interference with Novo. I assume it's going to drop the claim, but it would be really funny, and I personally would be very pleased if they continue to litigate that
sure.
claim.
Maybe the damages there are the
marginal
higher.
Bid. Exactly. Like the damages would be, we should never have been forced into this posture.
Oh my God!
Where we had
if you're Novo and you lose that, or you have to settle that.
Yeah, it would be hilarious, but I rather suspect they're going to drop it. But if they didn't, it would please me personally, and obviously I think that should weigh very heavily on their minds.
We'll make sure they know that these two podcasters want to see what happens with the federal court matter. Yeah. Oh wow! All right, so what we have here now is that Pfizer is going to be buying Metsera. Did they say when this should close?
This week. Yeah, it's scheduled for November 13th.
Oh, so this is going to close like this month.
Yeah.
All right, so maybe Pfizer will be back in the GLP-1 business.
Exactly.
We'll sort of see what happens. Wow, this is really cool.
There's litigation over the CVR, so that'll be fun too.
Like
over.
There
usually is. over whether it's like if
CVRs,
they miss the milestones, all that.
Right. If they earn out litigation is going to be what's left, right? I think that's what's going to happen. All right.
Well,
cool.
it usually does.
All right. Well, this is great. Hopefully, all the law students that were listening to this will take something away from this too. So, let's wrap up and move on to other subjects like in the coming weeks.
Yeah.
This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is professor of law and the Lawrence W. Demuth Chair of Business Law at the University of Colorado Law School. You can find me, Mike, at theactivistinvestor.com and Ann at law.colorado.edu. Our podcast is produced and distributed by our good friends at Free Float Media. Thanks for listening. We will talk again soon.